Hello, everybody. So today we're going to talk about school discipline within schools. My name is Marky Dunhauer, and I'll be walking you throughout this research. What we're really going to focus on today is the history and the laws for student rights and disciplines in schools, and then present laws that have kind of changed or more modern, addressing the problems that are relevant today. And then future changes or plans that I think should be taking place from an academic standpoint. I currently teach fourth grade. I am looking to stay in the elementary school realm, so this has a elementary focus on it. In a lot of these terms, they could be transferred to both middle school and high school, but for my research, I focused more on the elementary and just the student rights or in around the realm of discipline. So the first thing we're going to start with is history. So prior to the 1970s, school choice needed to be reasonable. It was stated that it had to be reasonable in order for administration to be able to have a discipline or be able to represent their discipline. That changed a lot by Tinker versus the Des Moines Independent Community School District, in that students do not shed their constitutional rights to freedom of speech or expression at the school gates. And so that really started to open the door for that shift. Within that time frame, we also had in 1972 Title IX for the educational amendments, and it expanded the rights for female students. And then in 1974, we had the Family Educational Right and Privacy Act, known as FERPA, and it focused on protecting information concerning students. So the student's name, address, telephone, date of birth, place of birth, major fields of study, like what they're participating in, sports, what their weight was, their height was, the number of athletes, like anything that could have done with students was protected by that act in 1974. The other main one that happened before the shift in the mid 1980s was the Education for Handicapped Children, and that provided for free, appropriate public education for all disabled children. So that made it that schools had to be handicap accessible, and that students needed to be able to go to and participate in activities at the school. And then that leads us up to the shift in the mid-1980s. This shift was where the students needs as a result, students were often successful in challenging school policies and procedures because it was for the students' rights. That's when that shift happened, where schools had to have more data, more evidence, more support in what they were, what disciplines they were putting onto the students. So school officials believed that this was the time that they lost the authority within the school. They couldn't do it on their own. It had to be like a public policy or something that would change that process. That puts us into the history of suspension and expulsion. So that puts us at Gross versus Lopez Supreme Court in 1975. And that was like the right to a hearing. So when we got into this, it was the main things that came out of this Supreme Court case was three main things. The first thing was that immediate removal of the student who conducted disrupts the academic atmosphere of the school, endangers fellow students, teachers, or school officials, or damages property. They could be suspended for those reasons. Then it required a notice of suspension proceeding to be sent to the student's parents within 24 hours of the decision to be made. The third thing was requiring a hearing to be held for the student within 72 hours of the removal. The The court also stated that represented to the hearing could be people for or against, and statements for the defense and for the mitigation were allowed to be shared to the council. This gave people being suspended a lot of grace and a lot of ability to be able to fight it, because if the school system did not go through these 3 steps, it was easy for a court system to say, well, you didn't follow the law or the regulations on what you needed to do. And so following these 3 strict guidelines of it had to be why a student would be suspended, notifying the parents, and then having the hearing within 72 hours of the removal were vital to being able to keep that student either suspended or expelled, depending on the severity of the situation. Of course, the students were entitled to a hearing before they were expelled or suspended, since their actions totally excluded those from the educational process. But teachers should be free to impose minor forms of school classroom discipline, such as being able to take away things, take away privileges, not restrict the activities they got to do, require assignments. Those types of things are allowed within the classroom teacher's rights. So as we go through this, we also get into the different court cases that have been either for or around the suspension and expulsion processes. So we have Gonzalez versus McEwen, which stated that it talked about expulsion within schools and the importance of that and the process within it. It kind of goes off of Gross. Then we got more into the drug and alcohol use in the Lamb versus Panhandle community, looking at if it's something that shouldn't be at a school function or it's something like that, the alcohol and drug uses were taken out. Then you have Cringe versus Salem City Board, and that was for fighting. So anything that's unsafe or not allowed around the school system is always something that could be used to have a kid suspended or expelled. And then the last one on here is the Gun to Free School Act in 1992, and that was for the safety of the schools. So that really enforced the shift in if there is somebody who is threatening or having caused something that could further down the line be a threat towards another student or to staff or administration, then it is taken seriously and kids can either be suspended or expelled depending on the hearing process. Some more present laws that are important to the school system today is the unauthorized recordings. So this is a Washington state legislative law for like recording, taking pictures, audio, video, visual, sharing those photos of stories or publishing them. It is pretty much, it goes with FERPA on student safety and the protection of our students. And now in the 21st century where we have more phones and students are having phones more often, and there are watches and there are several ways to communicate and talk, the importance of protecting students with digital or video photography is really, really important. This goes back to the CNN report that we used in our data or in our stories, and it was focused on even a photo taken of a realm of people. So it was a large group of people, but it's still photographed several students in a building, And while this went to a case, it was seen that she definitely used her video and photography in a way that wasn't appropriate at school, and she accepted that. One hard thing from an elementary standpoint is students really aren't allowed to have their phones. In the middle and high school, students are allowed more to have their phones within them or with them while they're at school. But from an elementary standpoint, it is less likely that students will have phones with them, so this doesn't become as large of a problem. But there is still a need to regulate and have those policies put in place to be able to see, like, okay, has this changed? Are more younger students having their phones? Do we need to implement more things in the realm of like social media and protection there? Another thing is like cyberbullying. While it is a newer topic and it is something that needs to be focused on, there is a lot of either over video games or over text messages or different things where people can be disrespectful and biased for several different people, and it can be a real problem that can carry back to the classroom. Both parents and students know the expectations going into things and having those set guidelines to make sure the school runs smoothly, and that as an administrator, I know what I can and cannot do to be able to truly support the students in my school. Lastly, like I talked about earlier, social media, as it becomes more and more of a problem with the ability for students to learn different things and communicate with others in a way, we need to have devices in school to help better educate students, to have cyber education, so there is more accountability for students when they get on and do things online, or that they know that if I go on and do this thing, there's proof to what I have done, and somebody else could pull this up and use this against me, and being able to really teach and have some of those policies in our schools to benefit not only the school itself from having to go through the repercussions of some of those issues, but the students from making sure that they are aware of what can happen if they do something online that is unsafe or not allowed or disrespectful, and really guiding them to be able to be good cyber users on all platforms. Overall discipline in school has changed quite a bit over the years. There has been shifts in student safety and student abilities, and not taking the freedom of speech and the freedom of their choices away from them. It has caused for administration and teachers to have more guidelines put on them. So making sure that your staff knows those guidelines and making sure that everybody in your building knows what they can and cannot do are vital pieces to making sure that your school stays safe and that there aren't policies or things that could happen that could shut you down. Overall, just making sure that the disciplines and the choices that are made are for the betterment of the student and for the safety of the school as a whole. Here are my references. I really hope you enjoyed hearing about and discussing the school discipline with me, and hope you enjoy.